Okay.
Okay, you're recording.
Yes, it says Forrest Solutions. That's the main screen, so that's fine.
That's it. You're up.
Okay, perfect. Perfect. So hello, everyone. Before we get started, if everyone here, first off, I'm Deanna Bernard from Forrest Solutions, and I'll do a formal introduction in a second. But if I just so I can know, if you guys can type in the chat box what state you guys are from, so we know where a cross section of everyone is coming from. If you wouldn't mind doing that, DC, New York, Delaware, New York baby, California, Colorado, Texas, North Carolina, Massachusetts, California again. Okay, this is fantastic. Okay, great. So this is wonderful. And yes, and so greetings from the Big Apple. Perfect. In Florida. Oh my God, some of you are living in places where I wish I could be in the wintertime. So we'll go from there. So let me get started. Thank you for coming to the second webinar that Forrest Solutions is hosting. We hope to share information about the Families First Coronavirus Relief Act. So here, I'm Deanna Bernard. I'm Vice President of Sales here at Forrest Solutions. I also have joining me my subject matter expert, Adam Guttell. Adam works for Jackson Lewis, and I'll let Adam tell people a little bit about yourself.
Sure. So first of all, thank you, Deanna, and thank you, Forrest Solutions, for inviting me again today. I know we did this last month, and I know Forrest Solutions is going to be doing these types of webinars on a regular basis. It's a real value add for your clients and your customers and sort of the outsourcing community. So whether it's me or another subject matter expert, definitely this is something that, in these times where we're all locked in one location, it's good to get this extra information. I'm an employment attorney. I work with Jackson Lewis, is the firm that I'm affiliated with. We're one of the largest labor and employment firms around the country. We've got about 60 offices all over the United States. I'm a litigator by training. So what I do is I represent management, employers, in claims that are brought by current employees, former employees. By defending those cases, we learn a lot of information about the best practices of what to do and what not to do. So I also advise clients before they do have a problem, because a lot of times the goal is to avoid litigation. Litigation is a costly and time-consuming endeavor, whether it's by someone bringing the case or someone defending the case. So sometimes you can't resolve things, but sometimes you can stop problems before they occur. And that's what we do a lot of. So today, hopefully I can give you and the people attending some good information that can give you something to think about as you're making HR decisions.
Perfect. Thank you, Adam. And also too, I would be remiss if I didn't tell you a little bit about Forrest Solutions. We just celebrated our 46th year in business. We are a national both staffing and on-site outsourcing firm. We are headquartered here. I'm in New York City. That's where we're headquartered, but we have people and placements all across the country. And we work to help with your staffing, direct hires, on-site outsourcing, contingency, temp placements as well. So thank you so much for joining us. We're going to get started. We did have a previous webinar talking about the FFCRA, the Families First Coronavirus Response Act. Say that 3 times fast. But we're going to do a follow-up here because there may have been some changes going on there. So let's start off first, Adam, with just what is the Families First Coronavirus Response Act, and when did it expire or will it expire?
Yep, no, that's a great question, Deanna. When we spoke last month, there was a lot of activity in Washington about whether or not there was going to be another stimulus bill, what Congress was doing, what the White House was going to sign on to, and nothing had passed at that point. So the big question was, is there going to be an extension of unemployment benefits? Is there going to be are there going to be more stimulus checks going out? As we know today, sitting here, there was a new bill that Congress passed after our last session, but before the end of the year. And what that bill did not do was it did not extend the FFCRA, or the Family First Coronavirus Act, which was a law that was enacted by Congress and signed off by the president back in the spring when the coronavirus really took hold in the United States. And it does a couple of things. it expanded eligibility for paid leave under the Family Medical Leave Act for individuals who have children at home, who are unable to go to school because the school was closed, or they have a daycare provider and the daycare provider was closed. And what it did was it gave paid leave up to, I think, a maximum of $10,000 for about 2/3 of the employee's pay, up to a maximum amount that's capped. If that occurs, there's also a certain amount of unpaid leave under that component of the law. But what most employers were challenged with, and most employees were using going forward, was really the component of that act that provided paid leave related to COVID. And there's about 8 factors or 8 options that someone can get that relief for. And the most sort of catch-all one was someone having something related to COVID. Either you're taking care of someone who's been diagnosed with COVID. You yourself have been diagnosed with COVID. You think you might have COVID, but you're seeking a diagnosis. All of those were reasons that the law allowed you to take leave from work and allow that leave to be paid, again, up to a maximum of $511 a day. And it caps out at 80 hours. It's a one-time thing. So it's not that someone could keep taking that time off. So 80 hours. And if it was a part-time employee, that averages out. If you work 20 hours one week and 40 hours the next, you get the average of the 30-hour a week. And that's it. I mean, it was giving some relief. And the benefit there, and this is a tax issue that every employer should speak to their accountant about, is that you could get some form of tax credit for the money that you're paying in that paid leave to the employee. Now, the new law that was passed by the law expired on December 31st of last year. So it has not been extended into 2021. And the new law did not do anything with that, other than to say that if an employer is utilizing the FFCRA for their employees, they can continue to do so. It's not a hard stop. They can continue to do so up through March of this year. And sort of roll it over. But then that's going to be it, unless there's more legislation. And I just read this morning that, there's a lot of hubbub. There's a new administration coming in on the 20th. And some interest groups are already lobbying the Biden administration to expand the FFCRA. And given the state of the country right now with respect to the COVID numbers and people having to take time off of work, I would not be surprised if that's something that does happen. I can't predict it, but that's the issue.
Okay. So we have a follow-up question, but before I ask that follow-up question, Adam, everyone, if you have any questions, this is an open forum. Feel free to put them in either the chat or the Q&A, and I'll make sure that I'll ask those questions for you. So the first question we have is, so the sick time expired, but can they continue it through March 2021?
That's right. They can continue. That was sort of the last comment I had, which was it can continue through March of 2021, unless something changes, between January and March where they extend it. And again, it's a sort of a one-time use thing. So it's not, if this was the same sort of structure that like FMLA, everyone should be familiar with FMLA. If you have an eligible employee, you have over 50 employees, and you need to take some leave for a qualifying reason under the FMLA, that resets every 12 months or every year. So that's not what's going on with this law. This is just sort of, so it's not a hard stop extended into March. Okay.
And then follow-up question is there an elimination period that the employee must satisfy first?
I'm not sure what the question means by elimination period, but like for FMLA, you have to, work there for, you have to work 1,250 hours in the prior 12 months to be eligible for FMLA. That is not the case with the COVID leave under the FFCRA. It's available to employees right away.
From day one, like if I started a new job today and tomorrow I was determined that I had COVID, I would be able to have this.
But not the FMLA component, which is separate.
Not the FMLA, but the other portion. Okay, perfect. Okay, yes, we answered the question. You answered the question. Next question I have for you. Can employers voluntarily provide paid leave benefits for tax credits under the FFCRA?
So in terms of the extent, they have a choice, right? You can say, well, it expired on the 31st and that's what we're going to do. We're no longer providing that benefit for whatever motivation the employer has. You're not violating anyone's rights. I've not seen the questions we get are not employers who want to end it. The questions we get are employers who want to extend it. So yes, you can continue extended, but just through March, right? And then you get everything that goes along with it, which include those tax credits. So if you voluntarily as an employer continue to provide that sort of leave or benefit beyond March of this year, no, you're not. You're doing it as a matter of company policy. You're not doing it because you're required to under the law. And in all likelihood, you would not get the tax credit benefit because it expires at that point. Again, all subject, this is a moving target. Things are going to, we expect things are going to change. They've been changing in the last month. They're going to change even more probably, in the coming months. So
Okay,
we'll probably be doing this again next month, talking about any new changes, because, and this is interesting, there's different ways, if you're not dealing with this on a daily basis, you're not thinking about, where requirements come from, where laws come from. You've got going into January, without getting political, you've got going into January 20th, a new Senate and a new presidential administration. There's a variety of ways that the federal government can change laws. One is what we've been talking about, the FFCRA, which was a legislative act, a law that was passed by Congress and signed into law. It was actually reconciled with the Senate. Congress got together, the Senate got together, they made some changes, and then the president signed it. And it was actually a fairly collaborative effort, given everything that's going on, in our current political environment. Back in March, when we were confronted with COVID for the first time, Washington got together and did that. So now going into this new administration, they could pass new laws because you've got a Senate and a Congress that is primarily of one party, and you got a president of the same party. The president also has the opportunity to sign executive orders. And there's a lot of press in New York when COVID started in terms of executive orders by the governor. A lot of the regulations that we have in New York State are because the governor here issued certain executive orders, because to move these types of laws through the state Senate would take a very long time. And when I talk about executive orders in New York, it's like closings, right? Remember when it was, well, you can only have 75% capacity in the office. Then it was only 50% and 25%. And then everyone had to be closed unless you were an essential business. Those were all done through executive orders of the governor. So the president has the same power and can issue executive orders. The president can also rescind executive orders that the current president has issued. So I think starting on January 20th afternoon, we're going to see a lot of action. And if we're back here a month from now in February, I think there's going to be, we're going to need all day to talk about some of the changes that are taking place.
Probably. Since you mentioned that, with the events that happened last week, and not to be political, but everyone on here are professionals, and they are either HR or they're leading people. What do you suggest are ways they can make sure that they keep the temperatures down in the workplace without affecting free speech and all of that? So we can just focus on getting work done.
Sure. No, it's an excellent question. It's probably top of mind for a lot of people. One thing I always say when I do say New York State has a requirement for anti-harassment, anti-discrimination training. And so I do that, and you talk about, what is harassment in the workplace? What is sexual harassment? And what I do is I sort of lead off and explain to people, look, everyone's here to do their job. No one needs drama. No one needs nonsense in the workplace. If you have that mindset, no one's going to get in trouble. No one's going to have to deal with trouble. Right. But that's not human nature. People like to talk. They like to express their views. And unless you work for a government employee, a state, the federal government, a city, a municipality, there are no First Amendment rights in the workplace, right? So for a private employer, and employers can restrict what happens in the workplace. You can restrict political speech. You can restrict people posting certain things in their workstation. Believe me, I've had the question over the last 4 years. We have an employer will call and say, we have an employee who wants to put some political signs around their cubicle, and the people around that person vehemently disagree with that. And so there's a dispute. We don't want to disrupt the workplace. That's not what we're here to do. For a private employer, you can do that, right? Now, how do you do it is the question. Do you want to, are you offending one employee over another? Are you taking sides? You can do it, but the better approach is to what's the neutral policy, right? If the policy is, we don't want people posting, outside information. You can put pictures of your kids and your family up. If you like golf, put a picture,
Right.
of your golf clubs up. But, we don't want any of that stuff in the workplace. And you're allowed to do that. Now, it crosses over if someone feels that they are being treated unequally because of a protected category. That is a different story. So the federal law, Title VII, and the Americans with Disabilities Act and the Age Discrimination and Employment Act provide certain protections at the federal level. And as you get down to the state level, there are more protections, and some cities have even more. So New York City is a good example. New York City expands the list of protected categories way beyond what the federal government provides for. And that what that means is you as an employer can make a decision as long as it's not based on someone's protected category, based on skills, experience, performance in the workplace, but you can't make a distinction between someone who's one race, gender, national origin, et cetera, versus someone else. And so if an employee says, well, I think I'm being treated differently, my coworker is allowed to express political speech and do all these things, but my coworker is of a different protected category than me, race, gender, national origin, religion, what have you. I don't think you're making that decision because of political reasons. You're making it because you don't like someone like me, of my protected category. And how do I know that? Because I've heard the comments you've made, or there are emails that were sent, or there's some indicia of discrimination that comes out there. So as an employer, you have to be very careful because, as we defend these cases, and I see a lot of this, it's, employees and the individuals who will bring these claims, even if there is no indicia of discrimination, someone's going to find something. So you want to be very careful and think about that. And that's really the focus when you're talking about sort of taking the temperature down nowadays.
Okay, perfect. Thank you.
Sure.
While you were talking, we had some additional questions.
Yep.
Okay. So some of them have acronyms and initials here. So hopefully you will understand these. Can you confirm if the HDDS has renewed the National Public Health Emergency through January 20th, 2021 or further?
So I'm looking at the chat here, H.
Came in at 1:15.
Yep, no, I see that. I'm not familiar with that acronym, so that is something that I could look up at some point and figure out. It may.
Wait, hold on. I think she clarified it. Hold on. The U.S. I think Department of Health and Human Safety.
Yeah.
I think that's what it is.
Yeah, I don't know. I don't know the answer to that. Assuming there was an issuance of a national public health emergency, that may be the case. I just don't know the answer to that. And that
okay. So we have another. I'm sorry.
That may be an OSHA question. It may not be something that I've dealt with recently.
Okay, so I have another question. This is Colorado specific, so you may. Let's find out.
Yeah.
On December 23rd, 2020, you guys, I'm reading, so bear with me. The Colorado Department of Labor and Employment issued new rules implementing the Healthy Families and Workplaces Act passed earlier this year. The most urgent clarification was an interpretation requiring employers to provide employees up to 80 additional hours of public health emergency leave beginning on January 1st of this year.
Okay,
and you're nodding, so.
That's great information for Colorado employers. I have the luxury, unfortunately for everyone here, that if I do get a question about a state other than New York, I call someone in our Denver office, for example, and ask them that question. But that is not uncommon as to what's going on in other states. So the one thing I didn't mention with the FFCRA is, even though that expired on the 31st, except for this extension into March, every state has their own laws, right? So New York, and by comparison, I can talk about Colorado and New York. New York has its own paid leave. So if an employee after March is no longer eligible for some sort of federal paid leave, New York State has its own paid leave, and it can be, depending upon the size of employer, it can be up to 2 weeks of paid leave, and based on a COVID-related reason. Now, New York early on, even before there was the FFCRA, had passed, I think it was an executive order, basically requiring paid leave based on an order of a quarantine or a quarantine order. And there was a lot of controversy about what does that mean? Does that mean if I go, if I get a positive COVID test, is that a quarantine order? At the time, the answer was no. You had to actually get a physical quarantine order from a government agency. And at the time, everyone was overwhelmed with everything that was going on, and the government was really not issuing those, although then they started issuing quarantine orders. If you flew into New York, they would hand it to you at the airport, or if you got pulled over with an out-of-state license plate. Now the state is actually pretty good about it. If you as an employer notify the Department of Health, oh, we had a positive test in the workplace, they're gonna do their contact tracing, and through that process, they tend to issue a quarantine order. That's just the New York example.
Okay, thank you. Continue to send in your questions. Even though we may go on to a different topic, still send in your questions. The next topic up is something that's near and dear to everyone, or top of mind, is vaccinations, Adam, okay?
Yep.
Are you afraid of shots? Are you a needle person? Do you?
It doesn't bother me, and I'll line up the moment that it's available to my class.
Go ahead. No, I look, and they're like, why are you looking? Like, I rather see what you're doing, so.
Right. And I can tell when I get blood drawn, you can always see the person who's like, you're like, oh, you're really good at that because I didn't feel it. And then sometimes you get someone who's like, oh, that was really bad.
They were practicing on you.
Yep.
Okay. So here's the first vaccination question.
Yep.
Can I require my employees to get vaccinated before returning to the office?
Yeah. So, we've been getting that kind of question, and the EEOC which is the Equal Employment Opportunity Commission, has issued guidance on this. And, you need to, I've not encountered an employer yet who wants to mandate. They want to encourage, which is a good thing, but you can maintain policies in the workplace that protect your other employees and your customers and the people that they're dealing with in the public. And it's similar to what's always been the case, especially with healthcare workers and certain vaccinations. Hospitals, for example, said, we want you to get the flu shot. And then there were employees who said, well, I choose not to. Well, there are two exceptions to choosing not to take a shot that may be necessary to be in the workplace. One is an accommodation for health reasons, and the other is an accommodation for religious reasons, a bona fide or sincere held religious belief. Those are reasons that you can, employees can refuse to take the shot. So for example, a health reason, if if employer encourages someone, their workplace to get the shot once it's available to that classification of employees, and people come to that employer and say, well, I'm not going to, because here's a note from my doctor that says I have a chronic condition, and my doctor says, I think, in my medical judgment, you should not be getting the shot. Okay. The accommodation then in that case is, what can we do to enable that person to perform the essential functions of the job? Is it working? Is it remote work? Is it making sure that person is maintaining the proper PPE? Is it putting that person in a separate location? Those are all things, very fact specific.
Right.
The other is a religious exception, not as high a bar, actually, or however you look at that analogy, a higher bar to meet than a disability accommodation, because it depends. Is it going to be an undue burden for the employer not to have that person get the shot just because of a religious reason? And what is that religious reason? I mean, I've researched that before because I've had cases on religious accommodations. You don't have to be a member of a recognized religion that everyone has heard about. There are some fairly smaller religions, or people identify with certain religions that the common public may not have heard about. That is not a reason to say to someone, well, that's not really a religious accommodation. So you have to be very careful. In all of these issues, you want to talk to your HR person, professional. You want to talk to your employment lawyer. It's very important to get the right kind of guidance, because what you're going to find is a lawsuit sitting on your doorstep. And that's sort of our goal in these conversations, is to avoid that process. It's not good for anyone. It's not good. The only person it's good for is me. It's not good for the employer, because you're not getting work done. It's not good for that individual, because they don't want to, have to bring a lawsuit and then, compromise that relationship. So it's better to try to address these issues and get the right answer.
Okay. Thank you. The next question was, what if someone refuses to get vaccinated? But I think you addressed that going forward.
Yep.
Okay. So moving on to, with the new administration coming on, what are some of the expected changes that employers may have to deal with the new administration? So
there's a lot of things, and we could probably spend all day on this, because you're looking at two, and again, without getting political, what we're anticipating is two just different views of how law are going to be enacted, what should work, what shouldn't work. There's been some interesting things that have happened before I even get to that. with this current administration that are changes that employers can look to. The Department of Labor issued 2 new decisions or guidances, however you want to call it, over the last short period of time that will affect employers. If you are a restaurant or hospitality, there's a new, they eliminated this rule on tip pooling, right? And this is something where this was always a very controversial issue for people who run restaurants. If you pool tips between people who are actually doing the frontline work, serving, and people in back of house, dishwashers, cooks, people in those positions. And where employers always used to mess this up, whether or not you could actually pool tips and then distribute them. The DOL came out and said, yeah, it's fine as long as everyone's making a minimum wage who is not someone engaging in that sort of tipping process, or like a server, right? And so that's a new rule. And there used to be this analysis of whether or not 20% of their duty could be, at least 20% had to be non-tip duties. That they took that out the window now. So that's not an issue. The other thing is the Department of Labor also issued guidance for, designating between independent contractors and employers. And to me, that seems to be a very fertile area for a lot of litigation, because the question, and we get this question all the time, people will call and say, well, I want to treat this person as an independent contractor, right? Well, what are they doing for you? Are they really an employee, or are they an independent contractor? And there's a lot of exposure there if you get it wrong, because you have tax exposure. If someone's treated as an independent contractor, you're not paying payroll taxes. So the IRS may want to look into that. You have state level exposure because that person, you're not making unemployment contributions. And the state may have one set of rules for it, and the federal government may have a different set of rules. And then you have your exposure with that individual, because that individual may one day turn around and say, hey, I worked, I was non-exempt and I worked more than 40 hours a week, so I'm entitled to overtime, and you were just paying me some flat rate every week. Right. So you want to get that right. What the Department of Labor came out and said that you really want to look at 2 factors now to sort of clarify the analysis, right? And the way I always looked at it is it's direction and control, right? If someone, look at your house, right? If you have someone working on the outside of your house, like a gardener, right? You don't know who the gardener's hiring. You're not, hiring the individuals working for them. You don't know who shows up from time to time. You get a bill at the end of the month or the week saying, here, we, mowed your lawn. It's going to cost X, and that's it. That's a true independent contractor. You're not providing the equipment. You're not telling them how to do the job, when to do the job, whether or not they can work for anyone else. But if you have someone inside your house that you're giving tools to, someone who cleans your house, or a housekeeper, and you're telling them when to show up and what to do and what meals to make and things like that, that's your employee, right? That's not an independent contractor. It's direction and control. But the federal government came down, the Department of Labor, and said it's the nature and direction of the work is one factor, sort of those things that I just described. And then that individual's opportunity for profit or loss is theirs. It's not based on you as the employer. So if a true independent contractor can either lose money or make money based on what they're doing in that business. And that's a very common issue, independent contractor versus employee, and something that you may want to, consider as you move forward, and having your employment lawyer take a look at how you're structuring your workforce, especially with this new Department of Labor rule. And then the other thing that's also new is sort of chipping away of non-compete issues, right? The Washington, D.C. just passed a law. It's got to be signed off by the mayor, limiting non-compete provisions in company. So you can no longer in D.C. have an agreement that restrains any employee from working from someone else after they leave, or operating their own business. That's a straight restriction of a non-compete. California also has their own sort of restrictions on non-competes by statutes. Different if you sell a business and whether or not you can compete after the sale of the business, something like that. But the reason I raised those sort of 3 changes, I don't see a trend one way or another, but that just shows you how active an administration or a government can be, sort of even in the last month. What you're going to see coming forward with the new administration, as I mentioned, executive orders and new legislation. I think you may see the Department of Labor look even more closely at some of the Fair Labor Standards Act rules in terms of how people are paid, and and how you classify employees. One thing which really affects all business owners, but it's not sort of an employment law issue, but we handle these. ADA, Americans with Disabilities Act, website accommodation cases. There has been a proliferation of these cases, I would say, in the last, almost 5 years, right? And what does that mean? Those are, if you operate a website and you're a business that holds itself out to the public, and that website is not accessible to people who are visually impaired, there are lawsuits that can be brought against you under the Americans with Disabilities Act, as well as state and local laws, to require you to make that website accessible. What does that mean? Well, what they're looking for in those lawsuits are injunctive relief, meaning fix your website. You want a court order to fix your website. And the lawyer who brings that lawsuit, yes, they're not asking for money, but they would get attorney's fees under the law. So the longer that case drags on and on, the more that attorney can say, look, I got a court order that forces you, company A, to fix your website, and I've now, it was $50,000 in attorney's fees. So they're really, risky cases to try to battle if your website is not in order. There's also compensatory damages, meaning that the person who goes on that website who is visually impaired can get an element of emotional distress out of it too. So what could happen in the next administration, which didn't happen in the last two administrations, and this is interesting. So these cases started to come up, and the Department of Justice, which was the organization that was tasked with trying to put in standards for these website cases, didn't do it. It just didn't happen this was the Obama administration. The Trump administration hasn't done anything with it either. And in fact, these cases got so bad that certain trade groups had written to Congress saying, we really need some standard here. We need some regulation to tell us as business owners, what do our websites need to do and not do? And the Department of Justice, so they wrote to Congress. There were some Congress people who took this up, went to the Department of Justice, who said, we're not going to get involved. So it's sort of hanging out there, and there are these sort of amorphous standards that these lawsuits are based on. In the court, every jurisdiction around the country gets a different decision as to whether or not a website is accessible or not. What you need to know as a business owner is if you have a website that's not coded properly and you want to talk to your website vendor or is ADA accessible? Because what happens is visually impaired individuals will hook up what's known as a screen reader, an auxiliary device to the computer, and that's what then spits back the information in verbal form. If it's missing stuff and if the website's not coded correctly, they can't access it. And the courts have held that that's the same as having a building that someone who's disabled can't access.
Okay, that sounds good. Okay, thank you. So we have another question going back to the vaccines.
Sure.
So here's a question. For biotech companies with various vendors coming in, once the vaccine is widely available, can we require them to be vaccinated before coming on site?
It's the same issue. Yeah. I mean, the EEOC has given guidance on that, which basically allows it, but you have to make these exceptions for people for health or religious reasons. Those laws have not evaporated as a result of this. You're going to have to work, I would work very closely with your employment attorney, whether it's us or someone else, to make sure that you are, pushing out a policy, first of all, that's worded appropriately in that respect. Mm-hmm. And then also implementing it the right way. If you have a mandatory program and an employee comes to you that says, here's a note from my doctor that says, I can't get it. Well, why? Do you have the right to then go back to that doctor and say, we need more information? Is that information, that's obviously protected health information. Where are you keeping that, so that the person's manager doesn't see that information, and then one day they can be accused of discriminating against them based on their, alleged disability. So you want to be very careful about how you manage this.
Okay, so I heard two things I want to just delve into a bit further. One is an employer can actually talk to an employee's medical provider, their doctor. And the second question I want you to give more information on, it was about keeping that information separate for folks.
No, so it's very carefully prescribed rules about how you can do that. I mean, the better approach is to have that employee then go back. You write to that employee gives you a note, and you write back to that employee, we need more information from your doctor. Please have them fill out this form. And that employee then obtains the information, then gives it to you. But if necessary, there is a way that you as the employer can speak to that medical provider with authorization to get this information. But it's very specific. And then again, as you raised appropriately, keeping that information separate. You don't want to keep that in the same general personnel file that contains everyone, all the other information, the application, the resume, reviews, things like that. That's protected health information and that should be maintained if you're a large enough organization by someone designated to keep that in HR, right? That's the person who's going to have access to it, who's going to need to look at it and review it if necessary, but not that person's direct supervisor, who really should have no contact with that individual about their health reasons. When you ask, for example, let's say someone has a reason to be on leave for a health-related issue or requires, they have surgery and they come back to work and they have something from the doctor that says, you can't lift more than 50 pounds for 2 weeks, things like that. You're allowed as a supervisor to know what someone can or can't do in their job, but you don't really need to know the detailed information about their health, because you don't want, for no other reason, the company doesn't want to get sued one day saying, aha, you took an adverse job action against that person and you did it because of their, health issue that you became aware of. It's a lot better to say, I had no idea, as the manager. I only knew that, I was told by HR that they had to take off work for 2 weeks. And when HR tells me, that's what I do.
Okay, so I have one more question about the vaccine, and then I'm going to jump back to FFCRA.
Sure.
So what happens if I'll use myself. I got to tell you guys, I have newfound respect for everyone on TV who's like a newscaster. This is very unique to do. So let's say I just refuse to have a vaccine. I won't do it for whatever reason, personal reasons. I don't have a medical exemption. I don't have a health exemption or anything else that could be considered legitimate exemption. What can my employer do if I refuse to take a vaccine, but they want you to have one to come into the workplace?
Well, if you, I mean, it's really the same question as before, right? If you have no other exception to that, the employer can mandate that program. But again, it's based on what's available. It's a little premature at this point to see what is available. And I think the EEOC guidance on this is going to evolve a little bit too. But certainly, let's say we're, everything's up and running and employers have that requirement. I don't want to give that advice now just because I know, and by the way, everything I'm giving now is not legal advice. This is more of a discussion. That's a disclaimer. I'm more than happy to talk to people on an attorney-client basis if they have specific questions. But for the most part, I anticipate that's going to be something that you're able to do, and then you can determine, whether or not it's appropriate to have that person work there anymore.
Okay, perfect. Okay, so this is, I believe, back to the FFCRA. Is there a limit to the amount of time employers can grant in sick leave to be eligible? I think you answered that. Is it 80 hours, the amount of sick leave?
80 hours for the COVID-related health reasons under the FFCRA, and it did not automatically reset at the beginning of the year. Although, again, I'm just predicting this, that if they do extend the FFCRA, I think it's going to be something more akin to like what you see with FMLA, where there's it sort of resets after a 12-month period. Okay,
I got you. So another question I have for you. A lot of folks weren't able to take time off last year because of what was going on and the lack of places to go. So what have you seen, or what have you seen when folks have had employees that have they allow them to roll over and it's a tremendous amount of time off, whether it's vacation days, sick days, PTO, whatever you want to call it. What are some of the things that you're seeing out there, and how should employers address that?
Yeah, no, that's a great question. I actually got that question just this morning from an employer. It really comes down to what existing policies you have in place. There is a bit of, let's take New York, for example. You have a lot of risk as an employer that if you have either no policy in place or a policy in place that allows for carryover and payout, let's say of vacation time, and then because of what happened last year, you want to stop that. Even if you can do that, there is a risk, and say to people, well, if you banked some days, we're not giving it to you now. There's real risk that individual can go to the Department of Labor or get a private attorney and say, this is actually a deduction from my wages and you owe me this money. And if any claim like that under the New York statute, there's a risk of liquidated damages, which means it's double not only the amount that the person's claiming they're owed, it's double that amount. And then if they have an attorney, the attorney can seek attorney's fees for the work that they're doing to obtain that money. So there's the exposure sort of compounds, right? And then if you do that, if you're a large employer and you have a lot of employees, there's a risk of a class action, right? Which is even a bigger risk of exposure. So what I do recommend is take a look at your policies. You may have a use it or lose it policy already that addresses what happens in the coming calendar year. So a number of things you want to look at. First of all, do you have employees who have contracts, right? Are they at will employees, or they're actually written contracts? Does that contract provide for some requirement or promise of paid vacation time? So you don't want to breach that contract, which is another cause of action employee. Mm-hmm. If the employee is not on contract, if they're just an at-will employee, what do your policies say? Do they talk about banking time? Do they talk about carryover? Is it a use it or lose it policy? You may be in a good position where it is a use it or lose it policy, and people may just be upset that, and may ask you, hey, I didn't have a chance to take vacation last year, so can I just, roll it over? If the policy is, no, you can't, but you want to make some exceptions, you can make exceptions, but you're gonna have to make that exception for every other employee because of what we talked about before with the political speech. Is someone saying, well, they're getting a benefit that I'm not, and why are you doing it? Is it because of some protected characteristic, or would they impute that it's a protected characteristic if they don't get the result that they want? So you want to be careful with that. So, and then finally, you could change your policies, but you want to do that very carefully. If you say, okay, we anticipate we're going to have this issue going forward, we don't have a use it or lose it policy, but we want to use it or lose it policy, you can do that. You can change it, but let's figure out what people have banked in the meantime, and whether or not you're going to be taking away anyone's money or benefits, but before you do that.
Okay, thank you. I have another question. So everything we discussed, from the FFCRA to the new administration and vaccinations and all of that, do you feel that there are going to be more lawsuits down the line because of this? Like, what do you foresee? I know it's good business for you, but what do you foresee that those folks that are on this webinar can be on the lookout for going down?
Great question. And early on, we actually had anticipated lots of new lawsuits, and I'd done webinars of, what are the types of claims that you could see people bringing. And I would say, just based on my own experience, we've not seen an explosion of lawsuits. We've seen a lot of pent up employment issues that, when courts were closed and now they're open and now everyone's, bringing claims. With the FFCRA, you could potentially see claims for like interference with people's FMLA rights or FFCRA rights if they don't get those. Those are pretty common claims that I could see people bringing. We haven't seen any yet. I had a case of someone claiming that they were terminated in retaliation for notifying their employer that they have anxiety over COVID, right? So we've seen some of those cases. I don't think the new administration is necessarily going to cause a proliferation of lawsuits. I think you're going to see some changes in the laws, but nothing that's going to promote lawsuits. I can tell you, California and New York over the last 4 years were fairly active states in terms of addressing employee rights and bringing on new laws, so that to the extent that the federal government had sort of pulled back a little bit, and this is a matter of just political philosophy, right? So you had a Republican administration, which tends to be a little more pro-business, and now you've got a Democratic administration that's going to be a little more pro-employee. You would tend to just see in the natural swing of things some changes, but New York, for example, and California have very active legislatures, and we saw some changes in the law. So New York, for example, the state human rights law changed, mostly in response to the Me Too effort, where you had claims for discrimination or harassment. They expanded the ability of employees to bring those claims within 3 years to a state administrative agency instead of 1 year, right? You had changes to how you would settle those cases. In response to a lot of things that happened, where there was a lot of issues in the press about people who had made complaints of harassment and then signed, NDAs or non-disclosure agreements in exchange for getting some money. Now the law in New York changed that so that you can do that, but The agreement specifically has to express that it is the individual's preference to maintain confidentiality. They can't be forced into confidentiality. And there's actually a 21-day waiting period for that person to sign the NDA and then to think about it. And they can always revoke, within that 21, or they have to wait 21 days to think about it. Then they have 7 days after they sign it to revoke it if they choose to do so. So
Okay.
my point in sort of identifying all those things is that the states have been fairly active when the federal government was not as active. I think we may now see a swing back where you have a more active Equal Employment Opportunity Commission, which is the federal agency that brings a lot of these cases.
Okay. So my next question, my kids are old enough and past college age and all the other fun stuff, but I feel for the parents that have young kids that are in school. So I feel for all of you. What happens if I have an employee come up to me, they do not have COVID, their children do not have COVID, but someone in their class, the children's class or the school has COVID. And so now they have to stay home with the children, but they don't have a job where they can work from home. How, as an employer, do I treat that?
So right now, New York State and the federal government, with the FFCRA, with the expansion of the Family Medical Leave Act, there was unpaid leave for, I think, up to 10 days, and then ultimately paid leave, I think up to $200 and something a day for a period of time for someone whose child can't go to school. And I think that may cover the scenario that you're describing. But it also would, I think, cover under the FFCRA this sort of scenario where there was like the eight factor, including a catch-all, because that person that they have to stay home and take care of, the child, was exposed to someone who tested positive, and I think New York may fill in the blanks there. But absent all of that, and depending upon what the state laws are, everyone's got childcare issues, right? So
Right.
if you don't have COVID as the employee, you have a job that doesn't require you to stay home or that allows you to work remotely, the employer may be in a situation to actually say, no, there's no accommodation we can make, but it's very fact specific.
Okay, that makes sense. Okay, perfect. So when I'm an employer, because someone on here has employees in 45 states,
Yep.
and so pretty much the whole country. So when they're doing their policies and they're setting it out, where do they do the standard? Do they do the standard towards California, which we know is very employee friendly? Do they do the standard towards New York, which is leaning towards that? Or do they base it on where they're headquartered if it's not one of those states? How do they ensure that they can offer a fair policy to everyone, but also still run their business and protect their business?
You really, fortunately for that person, it sounds like they have a robust business because they have business in 45 states, or they've got people working in 45 states. But unfortunately, every state is different, and there are things that you have to do in some states that you don't have to do in other states. And so it's not a one size fits all. I work with a number of clients that have operations in multiple states. And what we do is whether we do a separate handbook for each state or one main handbook with then addendums for each state that gets pushed out to the employees in those states, you have to do it. And in some states, it's actually a violation to not even have those policies. So you do want to make sure you have those policies that are applicable to those states. I'm more than happy to talk to that person because that's exactly what we do. And we sort of have a formula and a way of working this out that you're not spending, your entire operating budget on putting a handbook together. It's a fairly automated process that we can work with because we recognize how onerous that can be, but it is something you have to do. Not only you have to do because you want to have the right policies and procedures in place, but it operates as a defense in a lot of cases if you do get sued by someone who works in one of those states, because you want to then be able to have that affirmative defense to say, no, we had the right policies and procedures in place. You as the employee failed to avail yourself of the complaint policy or of the anti-harassment policy or what have you, because we did have it in place. And you lose that defense if you don't have the proper paperwork.
Okay, and then also for the FFCRA, I don't remember this, and I may have missed this. Does the employee have to use his or her own personal and sick time towards that, or is that something separate that won't affect their PTO vacation sick time? Is it two separate buckets?
It's separate unless your policy, you can run certain things concurrently. And again, that depends on how your policy is written. But for the most part, you don't have to force someone to take their vacation time if they're getting their paid COVID leave under the FFCRA. Totally different issue.
Okay. So I have another question for you.
Let me just raise, just before you get there, one thing that has come up that I've heard a lot about is, and when you asked this before with, are we going to get more lawsuits? There were a lot of layoffs and unfortunately furloughs that happened sort of in the spring and into the summer. That was something that, we can't sort of unring the bell on whether employers did that right or not. But fortunately for a lot of employers, they were then able to bring people back off of furlough, right? So one thing you want to look at, and when it comes to policies and vacation time and resetting amounts, do you have people who were active employees who maybe were furloughed and then just brought back on? Or do you have people who were terminated and then brought back on as new employees? And what happens with their accumulated leave at that point? That's another, whether a solution or a problem, depending upon how it was handled and what needs to happen going forward as to whether or not people get reset on their paid leave.
Okay, perfect. Okay, so I think it's gonna be one of the last questions. When did the FMLA, the Child Care Act, due to COVID get extended? They want to know when was it extended again?
So that was through March. Well, so let me be straight about it. The FFCRA did not get extended. It technically expired the end of the year. If employers choose to do so, and it's an option, they don't have to have a hard stop on it. They can continue it through March, right? And so that includes the COVID provisions of the FFCRA. You're sick, or you're taking care of someone who's got COVID, or you're seeking a diagnosis, and someone who has childcare issues related, and that falls under the FMLA aspect of the FFCRA.
Okay, perfect. Okay, perfect. Any further questions out there for anyone? Anything that's HR related, doesn't have to be FFCRA. We have a person who has been an employment attorney for a number of years, and it's a wealth of information for everyone.
Until there's another question, or at least, if not, let me say this is one thing that we've seen, employers really be challenged with, and at least, in the part of the country where I practice, is closings and openings, right? What's the government requiring you to do? How do you keep your employees safe? How do you keep your customers and your clients safe? I've been amazed by how nimble and flexible a lot of clients have been, because the goal is to service, their clients and customers, and keeping their workforce safe. And the ones who have been the most successful at this have had the right policies and procedures in place about social distancing in the workplace, about making PPE available to people, about having those daily checks about temperature and signing a form as to whether or not you've been exposed or not exposed, and and travel restrictions and things like that. The workplaces that sort of have that down are the ones that I've seen have been able to really function at sort of the fullest capacity that they're able to. So I would just, as a word of advice going forward, talk to your HR people, talk to your employment attorneys to make sure all of that's working, because I do talk to a lot of sort of smaller business on a daily basis who don't do those things. And when something happens, they have someone who's, tested positive, or they had, someone whose kid tested positive, and then they don't know if they can come in. It's a giant fire drill, and it causes a lot of disruption in the business. If you can sort of standardize and organize those processes, you're going to be better off in the long run.
Okay, perfect. Okay, so I'm going to do some takeaways now. So what I've heard today is FFCRA, you can, as an employer, choose to extend it if you want, because it did expire on December 31st, 2020. That keep your ears open, because things are changing constantly. When it comes to vaccinations, have talks with your employees and understand if they are deciding not to have it, the reasons why, and there's certain protected classes of the reasons why they can't do it. And if you have to, you may need to make accommodations. And there are changes coming down the pipe when it comes to the new administration and what's going to be happening there. So perfect. So Adam, before I close off, do you want to have anything to say right now?
Sure. I'll just, as these changes happen, we're publishing whatever we can on it, so you can see it. It's all, we actually have a lot of content on our website. Can I say what that is?
Yeah, Deanna? Of course.
Yeah. So jacksonlewis.com. Here's my contact information. If anyone has any questions, I'm more than happy to talk to you. It's my direct line and my email. I'm also, on LinkedIn and social media, where we, anything having to do with, any new laws or changes, that will affect the workplace, we're pushing it out there. So There's a lot of robust information, and I'm happy to discuss it. And I really do appreciate I appreciate Forrest Solutions inviting me to do this today, and everyone's time in joining us.
Perfect. Well, thank you, Adam. I cannot say enough. I've always learned so much when we have these webinars, and I'm hoping everyone else on the call did as well. I'm going to follow up with a few different things. One is we are going to have another webinar next Tuesday, a week from today. It's called Reimagining Your Office Services in 2021 with R.R. Donnelly, NQ ZebraWorks, and our Chief Revenue Officer, Anthony Davis, will be hosting that as well. So if you have opportunity to join, please feel free to join. Lastly, I'm going to call everyone here that's attended this. I will have, once we get the SHRM and HRCI accreditation numbers, I will reach out to you. So be on the lookout for my call, reaching out to you to give you that information. Adam, thank you so much. I appreciate it. On the screen is our contact information. Feel free to call, email, reach out for any questions. If we can help you, we definitely will. Thank you guys so much. Take care and stay safe.
Thank
Bye.
you.